penalty not only takes away the life of the person that has been convicted of, but also takes a little bit of humanity from each of us. Hello everyone, myself Aditi Todaria, and today I'm going to talk about capital punishment and all the aspects related to capital punishment in India. All punishments are based on the same proposition, that is, that there must be a penalty for every wrongdoing. There are two main reasons for inflicting a punishment. One is the belief that it is both right and just that a person who has done something wrong should suffer for it. The other one is the belief that inflicting punishment on wrongdoers discourages others from doing so. The capital punishment also rests on the same proposition as other punishments. Now, let's look at the meaning of capital punishment. Capital punishment, also known as the death penalty, refers to the practice of legally putting a person to death as a punishment for a crime they have been convicted of. The term capital punishment stands for the most severe form of punishment. It is the punishment which is to be awarded for the most heinous, grievous, and detestable crimes against humanity. The death penalty is a legal punitive measure in which a person is sentenced to death by the state as retribution for their crimes. The Latin origin of the word capital is caput, which means head. As you may have guessed right, this stems from the fact that capital punishment originally referred to execution by beheading. Now, let's look at the history of capital punishment in India. Capital punishment has been a part of Indian legal system since ancient times. The earliest known reference to the death penalty in India is found in Atharveda, a Hindu religious text that dates back to the second millennium BCE. The ancient Indian legal system prescribed capital punishment for a wide range of offences, including murder, robbery, and treason. During the British colonial period, the death penalty was widely used in India as a means of enforcing British law. After India gained its independence in 1947, the use of death penalty continued, with Indian Penal Code still prescribing capital punishment for a variety of offences. However, in the years since independence, there have been efforts to restrict the use of death penalty. In 1955, the Law Commission of India recommended that the death penalty should be abolished for all offences except for the most serious ones. In the year of 1980, in Bachchan Singh judgment, the Supreme Court ruled that the death penalty only be used in the rarest of rare cases. But it is not clear what defines the rarest of rare. The principle has been used by courts to restrict the use of death penalty in India and has resulted in a significant decline in the number of executions that had been carried out. Today, the death penalty remains a legal form of punishment in India, but its use is limited and controversial. Now, let's look at the constitutional validity of capital punishment in India. India is one of the nations that have neither totally removed the death penalty provision nor have passed legislation outlining its legality. The validity of death penalty has been contested on several occasions since the Indian Constitution was established through Supreme Court petitions and precedents. The constitutional validity of death penalty was challenged from time to time in various cases and in various ways. The Supreme Court's five-judge bench unanimously maintained the death penalty's constitutionality in the case of Jagmohan Singh versus State of Uttar Pradesh, concluding that it did not violate Article 14, Article 19, or Article 21 of Indian Constitution. In this case, the validity of the death sentence was contested on the ground that it contravened Article 19 and Article 21 because no procedure was provided. It was argued that the process outlined by CRPC was limited to finding guilt alone and did not include the imposition of a death sentence. The Supreme Court held that the choice of death sentence is done by the procedure established by law. It was noted that the judge decided between a death sentence and a life sentence based on the circumstances, facts, and type of crime presented during the trial. In the year of 1973, the Supreme Court of India again upheld the constitutional validity of the death penalty in the landmark case of Bachchan Singh versus State of Punjab. The court held that the death penalty could be imposed in rarest of rare cases, where the crime was exceptional brutality and heinousness, and the alternative punishment for life of imprisonment would be inadequate. In the case of Rajendra Prasad versus State of Uttar Pradesh in 1979, Justice Krishna Iyer asserted that the death penalty was a clear violation of Article 14, Article 19, and Article 21 provided by our Constitution. Two requirements for imposing the death penalty on any offender were highlighted in this case. First, the specific reason or circumstance for which the offender was given the punishment must be recorded. The second one is that it can only be applied in the extraordinary circumstances. In the well-known case of Ajmal Kasab, who was held guilty of 80 offences, including murder, possessing explosive, and waging a war in India, the Bombay High Court pronounced a death sentence against him, asserting that it was the only appropriate punishment for 166 deaths caused by the Bombay attacks on November 26, 2011. The death penalty was also upheld by the Supreme Court of India. Now, let's look at some of the provisions of death penalty in India. Section 354, Clause 3 of the Code of Criminal Procedure 1973 states that when the conviction is for an offence punishable with death or in the alternative with imprisonment for life or imprisonment for the term of years, the judgment shall state the reasons of the sentence awarded, and in the case of sentence of death, the special reason for such sentence. Offences under the Indian Penal Code 1860 that awards the death penalty sentences are Section 120B, that is for being a party to criminal conspiracy to commit a capital offence. Section 121, waging or attempting to wage war or abetting waging war against the government of India. Section 132, abetting a mutiny in the armed forces. Section 194, giving or fabricating false evidence with intent to procure a conviction of a capital offence. Section 195A, threatening or inducing any person to false evidence resulting in the conviction and death of an innocent person. Section 302, that is for murder. Section 305, abetting the suicide of a minor. Section 3072, attempted murder by serving life convict. Section 364A, kidnapping in the course of which the victim was held for coercive purpose or ransom. Section 376A of Criminal Law Amendment Act 2013 gives for rape if the perpetrator imposes injuries that result in the victim's death or incapacitation in a persistent vegetative state or is a repeat offender. Section 376AB, rape of a child below the age of 12 years of age. Section 376DB, gang rape of a child below 12 years of age. Section 376E, certain repeat offences in the context of rape. And Section 396, that is for dacoity with murder. Part 2, Section 4 of the Prevention of Sati Act also provides for death sentence And Section 31A of the Narcotics, Drugs and Psychoactive Substances Act for drug trafficking in cases of repeat offences also provide for the capital punishment. Now, let's look at the procedure after the imposition of death penalty has been done. The first one, confirmation by the High Court. The Sessions Court shall present the case proceeds to the High Court of the relevant state for confirmation of the sentence after the sentence is being imposed in accordance with Section 366 of CRPC. The sentence passing court is required to transfer the convicted person to jail custody with a warrant until the High Court confirms the sentence. Second, inquiry and additional evidence. According to Section 367 of CRPC, the High Court may order a further investigation of the incident or the collection of additional evidence at any point relevant to the convicted person's guilt or innocence. Third, High Court's power to approve sentences or annul convictions. According to Section 368 of CRPC, the High Court has the power to affirm a conviction, impose any other sentence that the court deems appropriate, or amend the charges and order a new trial. The court cannot confirm the sentence until the time allotted for filing an appeal has been expired. Confirmation of the new sentence. According to Section 369 of CRPC, any order or sentence that is submitted to the High Court for confirmation, whether it is a new sentence or the one that has already been passed by the High Court, must be approved and signed at least by 2 judges. Delivery of a copy of the order to the Court of Session. According to Section 371 of CRPC, the confirmation of sentence by the court or any other order passed by the Honorable High Court must be sent to the Court of Session without delay, with the High Court seal and attested with the signature of the High Court official. Now, look at the clemency powers. For the death sentence imposed by the Session Court to become final, the sentence must be confirmed by the High Court. If the conviction is upheld, the condemned person may file an appeal with the Supreme Court of India. If the appeal petition is denied by the top court, the condemned person may then submit a mercy petition to the President of India and the Governor of the state. The clemency powers are the pardoning powers that a President of India or the Governor of a state has. The President and the Governors have the authority under Article 72 and Article 161 of the Indian Constitution to grant pardon, reprieves, respites, or remissions of the punishment, or to suspend, remit, or commute the sentence of any person convicted of any offence. These are not personal powers of the holders of the office. Rather, they are to be exercised in accordance with Article 74 and Article 163, respectively, with the assistance and advice of the Council of Ministers of India. Now, let's look at what are the execution methods followed in India. First one being hanging. All the death penalties in India are carried out by hanging. After independence, Godse was the first person to be executed in India by hanging by the death penalty in the case of murder of Mahatma Gandhi. India's Supreme Court suggested the death penalty should be imposed on the rarest of rare cases in India. Second one, shooting. Under the 1950 Army Act, both hanging and shooting are listed in the military court-martial system as official methods of execution. Now, let's look at which category of offenders are excluded from capital punishment. First, minor. According to the law in India, a minor who is under the age of 18 at the time of committing a crime is not executed. Second, pregnant women. Clemency must be granted to a pregnant woman sentenced to death according to a 2009 amendment. Third, intellectually disabled. According to the Indian Penal Code, A person, while committing a crime, who was mentally ill or is not able to understand the nature of the act or the act is wrong, then that person can be held liable under the law and cannot be punished with death penalty. Now let's look at some arguments in favor of death penalty and against death penalty. Firstly, we will look at arguments which are in favor of death penalty. First, safety and welfare of citizens. Capital punishment is often offended on the grounds that safety has a moral obligation to protect the safety and welfare of its citizens. Offenders threaten the safety and welfare. Only by putting murderers to death can society ensure that convicted killers do not kill again. Good over evil. Capital punishment is one of such practice the society should support that will bring a balance of good over evil. The third, deterrence or prevention. Capital punishment is often justified with the argument that by executing convicted murderers, it will deter criminals from committing crimes. It also provides closure for victims' family. And the fourth one, retribution, which means eye for an eye, which means that a person should be done with what he has already done. He should be given the same punishment which he has done. People should get what they deserve in proportion to the severity of their crime. Criminals should get what they deserve and should suffer for their wrongdoing in an appropriate manner. Now let's look at arguments which are against death penalty. The first one is unjust to innocent people. The death penalty is also unjust because it is sometimes inflicted on innocent people. People go to death row because they have no money to appeal their case, or they have a poor defense, or they lack funds, or they are members of a political or racial minority. India is a very politically dominant country, and circumstances or situations like these are prevailing here. So this should be kept in mind. The second one is right to life, Article 21 of Indian Constitution, which provides every human life is precious. The right to life is the most important of the fundamental rights that has been provided under Indian Constitution, and no state should be allowed it to take it away so easily. The third one is rehabilitation. Capital punishment doesn't rehabilitate the prisoner and return them to society. Rehabilitation means restoration. A criminal can be, by training or by therapy, help them and change them, and their lives will not be wasted. Now look at some of the landmark cases of death penalty in India. The Supreme Court ruled in Rajendra Prasad versus State of UP in the year of 1979 that the death penalty would not be appropriate unless it could be proven that the defendant poses a serious and ongoing risk to social security. Three types of criminals, in the opinion of Justice Krishnan Iyer, should get death penalty. First, in cases of white-collar crimes. Second, for crimes against the social order. And third, for eliminating a dangerous killer who poses harm to society. The court further ruled that the imposition of death penalty for a murder conviction under Section 302 of Indian Penal Code 1860 would not constitute a constitutional breach. Capital punishment may be imposed in severe circumstances of extreme guilt, but the convict's health must be considered. The Supreme Court in the case of Machi Singh versus State of Punjab in the year 1983 laid down the guidelines of circumstances in which death sentences can be imposed. Justice Thakkar spoke about 5 circumstances which are mentioned below. Firstly, manner of commission of murder. When the murder is committed in an extremely brutal manner so as to arouse intense and extreme indignation in the community, for instance, when the house of victim is set to a flame to roast him alive, when the body is cut to pieces, or the victim is subject to inhumane torture. Secondly, motive. When the murder is committed for a motive that evinces depravity and meanness, example, a hired assassin, a cold-blooded murder to inherit property or gain control over property of a ward, or a murder committed for the betrayal of the motherland. Thirdly, antisocial or socially aberrant nature of the crime, where a scheduled caste or minority community person is murdered in circumstances which arouse social wrath or bride burning for dowry or for remarriage. Fourthly, magnitude of the crime. Crimes of enormous proportion, like multiple murders of a family or persons of a particular caste, community, or locality. The last one, fifthly, the personality of the victim of murder. In another case, the test of whether the death of penalty is constitutionally valid or not has been answered. In Rajendra Prasad versus State of Punjab in the year 1979, to which Honorable Justice Krishnan Iyer empathetically stressed that the death penalty is violative of Article 14, 19, and 21, he laid down two things that must be required to impose death penalty. First one, there must be a special reason which should be recorded. And the second one, it must be imposed only in the extraordinary circumstances. In a next case, which is named Bachan Singh versus State of Punjab, it has been explained that in accordance with an equitable, fair, and reasonable procedure laid down by law, the constitutional bench of the Supreme Court has recognized Article 21, the state's right to deprive a person of his life. In addition, there was no violation of the basic character of the Constitution by the death penalty of a murder offense granted under Section 302 of Indian Penal Code. Now, I'll just conclude by saying India is one of the biggest countries in the world, and as a result, there are a lot of crimes and criminals there. To deal with these issues, India has some incredibly strict regulations. Every offense results in punishment for the offender. The death penalty, which is rarely passed in India, is one of the corrections. A rarest of rare cases crime into picture while analyzing capital punishment or death penalty sentences. It is awarded to the convict for committing heinous and grievous crimes. There have been several discussions over the indigenous legitimacy of the capital punishment, and various people from various parts have expressed their views on it. Still, no definitive decision has been made. Thank you so much for being with me, and I hope I cleared all your doubts regarding capital punishment.